This is Ted Wagoner. Today we'd like to speak to you about one of the most important state officials in Indiana. It is the notary public. Indiana requires that a notary public be at least 18 years of age and a resident of the state of Indiana. The appointment is made by the governor, and it is for an 8-year term. And when you apply for a position as a notary public, there is a requirement that you provide a bond in the amount of at least $5,000, and you obtain that from your local insurance agent. The notary public's primary purpose is to administer oaths to people in the transfer of real estate and in other legal transactions. Oftentimes contracts are signed with notary publics. The process is to meet with the notary public, prove your identity, whether that is because you've known each other for a significant period of time, or by providing a valid piece of photo identification, such as a driver's license or a state ID. The duty of a notary public is to confirm the identity of the person, have the person identify the action they are taking. So if the person is signing a deed, ask them if they know what they're signing and the purpose of the signature. Then, once they determine that the person knows what they're doing and signs the document, then the notary public affixes their name, certain information that goes along with it, such as the date of their commission expiring, the date that the document is signed, and the notary seal. Once those are added to the document, then the document is notarized and is provided to the appropriate party. For many years, notaries in Indiana oftentimes had an embossed seal which was impressed upon documents. Nowadays it's more likely for it to be a rubber stamp that identifies the person as the notary public, and that it is in fact a sealed document, and it may contain some of the information that should be printed about the person serving as a notary. Indiana does have several cases where notaries have improperly handled documents. For instance, there have been cases in which a notary did not observe or receive acknowledgement that a person had signed a document. There have been cases in which a notary realized that a document was signed by a person who was not competent to sign the document at the time, but they went ahead and notarized it. Several of those cases have included attorneys who have been punished by suspensions or the loss of their license. Other cases have been handled under the criminal statute that prohibits the fraudulent use of a notary stamp. Under current Indiana law, the fraudulent misuse of a notary stamp is a level 6 felony, which is a serious crime. In Indiana, a notary is permitted to charge for notarizing a document, and the charge cannot exceed $2 per document notarized. All the staff and attorneys at Peterson, Wagoner & Perkins are notary publics, and we would be glad to assist you in notarizing documents that we help you prepare at no charge. If you have any questions, please give us a call at area code 574-223-4292 or stop and see us at 125 East 10th Street in Rochester, Indiana. Thank you.